Good morning.
Good morning.
Good morning.
All right. The first item on the calendar is the scheduling of a motion for admission of evidence of defendants' alleged prior sexual offenses. This was put on the calendar because the district attorney has asked that the hearing be sooner than later, I guess.
That's correct, Your Honor. We placed the motion on, in light of the court's earlier decision, which we wholeheartedly agreed in, that we should have testimony before the jury establishing the offenses that were committed by the victims themselves, on the victims themselves prior to the time of the hearing. And we believe that we have complied with what the court wished. And I think the court gave a perfect example of your experience of what happened to you before, where promises were made and promises weren't kept. I believe that we have at this point established sufficient information before this court and before this jury to now go forward with the 1108 hearing. We would indicate to the court that this would be the appropriate time. I'm not suggesting that we recess the trial at this moment. I want to make that clear. And I think I did in my moving papers. That we intend to move forward with probably evidence through, my guess is, if not through Thursday, probably into Friday of next week, based on the lineup that we have. We'll finish those parts of the case that are relevant to the allegations set forth against Mr. Jackson in all counts except for count 1. At that point, we will then be transitioning into that part of the case that deals with the conspiracy count. It seems to me that it is not only right and proper, but logical for the jury that this would be the appropriate time for us to be able to put on the 1108 evidence insofar as it relates and bears on the testimony of the credibility and the actions of the defendant in this case. And so we would request that at that point in time, that we then take up the 1108 hearings. So unless the court has any further questions, that's why we filed the motion now. I wanted to give the court sufficient heads up about it for scheduling for the jury, as well as the fact that we'll need to bring people in from out of county, and out of state in some instances, so we need some lead time for that. And clearly that whatever decision the court makes, we would have enough lead time for that. If we started next Friday, we could begin, and we'd be ready to begin. And if it was the following Monday, but you get the picture. It's at the point where we finish most of the testimony relevant to the charges against Mr. Jackson on the molestation.
All right.
Do you have any other questions, Your Honor?
I do. But I want to hear from the other side first, and then I'll ask my questions.
All right. Thank you.
Good morning.
Good morning.
The timing of the motion, we want to have adequate time to have the motion heard and be prepared for it. I don't concede at this point, by any means, that there's been a showing sufficient for the court to go ahead and make a ruling right now. And if the court were to make a ruling right now, I think it would be to deny the 1108. But having said all of that, the people I think are saying that they feel that they're going to be in their strongest position to make their 1108 motion by the end of next week, and I don't see any reason why we can't schedule a date to do that. We have two issues. One is whether or not they have presented sufficient credible evidence of the sexual offense crimes. And then the second issue, which would be taken up in the actual motion, would be what kind of evidence would come in, and whether or not the kind of evidence that's proffered is going to have sufficient probative value to outweigh the prejudicial effect in consumption of time, and so on. Having said that, if that's the court's understanding, I think we're talking about just picking a date now. And I don't see any problem with picking a date. A week from Monday, for instance, would seem to be a good time. Do you think so? Nods head up and down. Thank you.
All right, here's my question to both sides. Mr. Mesereau got me thinking about this from a request that he made earlier. And the issue? I guess the question is, should the court hear the evidence outside the presence of the jury? Or should I just hear arguments on the evidence, as represented to the court that it will be, as to whether or not the 1108 evidence should come in? And the thing that got me thinking about it was that Mr. Mesereau had suggested that they be allowed to put on testimony to attack, as I understood what he was saying, the credibility of the witnesses that would be called under the 1108, so that the court could make a determination, I think, based on credibility, as to whether or not the court would allow the witnesses to be called. And that was a unique suggestion to me, because I've had a lot of hearings under Evidence Code 401, 402, 403, preliminary fact, and I don't recall that. I laugh because there's a lot of things I don't recall, but I don't recall ever having that evidence put in at a 402 hearing. So, having that dilemma and working on it. One of the cases that we found was Vorse v. Sarasy, Sarasy, Vorse, being VORSE, 53 Cal. App.4 th 998. It's a 1997 case. And it suggests that the court is not to make credibility issue determinations. That, that my taking of evidence may not be proper on either side on this issue. It may be just that I am to decide whether or not it's admissible with an analysis of what you're offering. Whether that would, in fact, be 1108, and then make the weighing under 352 for all the reasons that 352 has the court make those, weighing those issues. It's interesting that the Vorse case cites another case, People versus Jackson. No relationship, but you can pick that citation out of the Vorse case. So I'm willing to let either of you respond to that at this time.
I would like to, although Mr. Sneddon's standing at the podium.
It's our motion, that's why. I figured you'd want to. No, after me.
Oh, after you. Okay, well, as they say, after you.
After you. After you.
Abbott and Costello. I hope we're not that bad. Judge. I think the simple answer to this is the evidence code provides your discretion to do it either way you feel comfortable with it. I think that the issue on the credibility, let me make sure I'm talking about precisely what the court asked. In terms of whether you wanted to have a 403 hearing outside the presence of the jury that did not involve the issues of credibility, okay.
Right.
Or whether you wanted to do it on the offers of proof. I believe that the evidence code clearly provides that you have the discretion to do that whichever way you want to do it. So, that's your decision, but with regard to the credibility issue, I believe we cited the Jackson case to you in earlier motions. We were aware of that. And not only in connection with the 1108 hearing, but in connection with some of the other pre-trial hearings that involved witnesses' statements, that we brought that case to the court's attention. If not that one, certainly there's another one that we did. So we were certainly aware of the fact that we believe that the credibility issues are those for the ultimate trier of fact, which is the jury. So I would say to the court that we are prepared to accommodate the court in either way in which you would like to do it. Obviously the most efficient would be for you simply, and with the ability of the defense to file, as you suggested to Mr. Mesereau I think a couple of days ago, their pro-offered. Although I don't know, since you can't weigh the credibility, what effect that could have on you. But in any case, we're prepared to do it either way that the court wants. And I frankly think that, given the way that this case is going, that probably the best case is simply to put these people on. And we'll put them on direct and they put them on cross and we keep the trial moving in front of the jury. But, of course, as always, we'll do what the court suggests. That would be my recommendation. And I do not believe the credibility issues, as you cited the case, are something that is really an issue in the 403 hearing.
All right, counsel. Mr. Sanger.
Yes, sir. The case law that I'm familiar with, and I won't claim to be specifically familiar with the Vorse case without looking it up.
Yes.
But just in general, it is true that the court's ruling on a 402, 403 type hearing for any kind of a determination, and under 1108 as well, is whether or not there is a threshold. The threshold has been met. And the threshold doesn't involve the determination of credibility in the sense that the court is saying, well, I just don't really believe these witnesses, so I'm not going to let the jury hear it, and usurping the jury's function, the ultimate function. But there still is a threshold level where credibility is one of the issues that the court is taking into account, and the court's taking it into account under 352. For instance, let's take an example, just a hypothetical example. Let's assume that one of the witnesses, a key witness that's proffered by the prosecution under 1108, is a witness who is going to say that she saw various things that were circumstantial evidence of some kind of activity, and that's their main witness. Let's just assume this. I don't want to argue about the facts of this case, but let's assume that that's the case. And it turns out that that witness made several prior inconsistent statements on television and eventually in a sworn deposition. It's not so much a weighing of credibility. It's not usurping the function of the jury to hear that evidence. But I think the court would want to hear that evidence, because under the three prongs of 352, number 1, you're looking to see whether or not the evidence is so inflammatory that it's going to be prejudicial to the defendant such that the probative value is outweighed by the prejudicial effect. Well, You have to figure out what the probative value is going to be before you can determine whether the prejudicial effect is going to outweigh it. And so therefore, you have to say, well, look, we've got a witness, for instance, who made a number of prior inconsistent statements on television, for money, and eventually under an oath in a deposition, and now this witness is being offered up. The prejudicial effect of just having this person come and say things may, in fact, be quite substantial in the court's mind when it's heard the evidence. And on the other hand, the probative value the court would have to find is probably fairly minimal, given the scenario I just gave. It would also go to the question the court has to address, the second problem, which is undue consumption of time. Are we going to have a hearing about this witness? And taking one of the witnesses, again, hypothetically, are we going to have a hearing that necessarily involves allowing the defense to fully defend it? As the court knows, and we've cited cases in our main pleadings on this, that were entitled, and not only entitled, but were required, it's ineffective assistance of counsel to fail to do a full of defense of 1108 evidence.
Right.
As if it were an independent case.
Right.
So we're not only entitled to, but we're obligated to. We're going to have to bring in all of those statements on television, for money, and before a deposition. And I'm saying that in a concise fashion, but Your Honor knows that's going to take time to bring all that out. So I think the court has to consider that. And then the third prong of 352 is confusion to the jury, or, I'm sorry, is undue consumption of time. I may have gotten those two confused, but thereby illustrating my point, I suppose. And so to take more time to further illustrate my point, you have confusion of the jury and you have undue consumption of time. And both of those, without restating the point, both of those are determined only after the court has a full opportunity to figure out what the heck is going to go on in front of the jury. Alright, so I think all three prongs. It's not a matter the court usurps the function of the jury by determining credibility. It's a threshold call, like many things are, and particularly things under 352. The court has to determine how this is going to play out in front of the jury. So you're not per se determining credibility, but you are saying, look, the credibility is going to be attacked substantially, let us say, after the court hears the evidence, and therefore the prejudicial effect is going to be great, but there's a little probative value. Therefore, there's an undue consumption of time, and therefore, there's the potential for confusing the jury. So I do think that we should be able to present to the court concisely, but I think with some live testimony, as needed from both sides, the evidence that the jury is going to see. And I think that just submitting it on paper would not adequately address the issue, particularly in a criminal case with the constitutional rights that are involved. Does that answer the court's question?
Yes, thank you.
Judge, could I address one other aspect of this motion that we haven't discussed?
Yes.
I will do it just briefly. But I wanted to remind the court that as part of this 1101, or 1108-1101 motion, that we had filed an earlier motion with regard to the admissibility of the civil settlements, so we had deferred that until this hearing process also. So I wanted to just make sure that the court did that.
Thank you.
And I think that's part of this process. And also, the guidelines with regard to what can and won't be asked I think is important. And there will be two separate, I believe with two witnesses, probably two separate civil suits involved, and so I wanted to alert you to that also.
Thank you. Those will be said at the same time.
Yes, sir.
If I don't say it, I intended to have those heard at the same time as this motion.
I don't know if you wanted me to address anything Mr. Sanger said. If you do, I'll answer the question. Otherwise, I'll just submit it to the court.
No, you don't need to.
Thank you.
Without ruling on that, because I'm not quite ready. I haven't quite made up my mind. But rather than spend the time now thinking about it, let's hear some argument on the other issues. Let's see. The objection to calling the grand jury witness.
Your Honor, we've briefed the matter and so I don't want to go over.
Yes, I read that again this morning.
Each one of the points. But what I did want to do is briefly augment it with reference to the grand jury transcript. And we did cite the transcript in our papers in an effort to keep things short. We didn't quote things at length and make a big deal out of it. We tried to follow the concept that this was a brief and, for a change, make it brief.
I appreciate that.
Okay, but looking at the actual transcripts of the grand jury, our position, as you know, is that if it's not in the transcript, That's too bad. The people are there to make their record and they know how to make a record. And we're not there. There's nobody there to object. If they wanted to have somebody put on gloves and look at things, they could say, we're putting on gloves, and so on. And, in fact, as the record shows, when you look at the actual transcript of the grand jury, and you look at the testimony of Timothy Sutcliffe, he talks about having gloves on. There's a question as to whether or not he had gloves on, and he had gloves on at one point when he was handling some what appeared to be moldy schoolbooks. When it comes to the end of his testimony, and you look at page 1245, and I have a clean copy. I'm sure the court has the whole transcript, but I have a clean copy, if it would help.
They're here. 1245.
1245.
What volume would that be?
That's a good question. I'm sorry, Your Honor, I just have the excerpt here.
I can find it. That's all right.
Okay.
Volume 5, I think. 1245 did you say?
Yes, sir, 1245.
Yes. Okay.
Okay, I just realized I didn't turn my cell phone off, so I'm going to do that real quick. It didn't ring, but...
I've done that. It's been embarrassing. I've been sitting in court and my cell phone has gone off, and I have to act like, whose cell phone is that?
Get that cell phone. Must be Mr. Sneddon, Your Honor.
Yeah.
If you look at 1245, this is sort of our smoking gun conversation here. And I know that the prosecution has some other version of it. But starting at line 14, does the court have that in front of you?
Yes, I do.
Since you have it in front of you, I'll just paraphrase and quote from the relevant source. But it's a grand juror who asked about the black suitcase, which was item 317. And it was admitted in evidence here as some other exhibit number, which I don't remember right now, but the black briefcase. And it had all the materials inside. And the picture, you recall, had the magazine on the top that had a date later than the relevant time period. And Mr. Auchincloss asked a question that the grand juror had proposed and said, did a forensic examination of some pornography in this case? I'm sorry, you did a forensic examination of some pornography in this case, correct? He says, correct. Now the question is, did you find any fingerprints on that pornography, usable fingerprints? Now, that's not a question asked by a district attorney who knows that there was no fingerprint analysis done. That's a question of a district attorney who is asking a witness, well, did you find any fingerprints, usable fingerprints? And the answer is, well, we're doing all this stuff. I'm paraphrasing. We used an ALS, alternate light source. They did a fluorescent check to see if there was any stains, and then they could do DNA, and they found no stains and no DNA. So the question is, so they haven't been examined for fingerprints? No, not at this time. And then they go on to explain the alternative light source thing. Now, at the end of the grand jury proceeding, when the jurors are about to deliberate, there's a part of the transcript where they show detective, I believe it was Zealous, has been instructed to wear gloves, and, you're not to deliberate while he's in there, but he's going to take these things out and show them to you. Okay, so by the end of the grand jury, clearly someone's wearing gloves and showing the grand jurors. Now, that doesn't, and I'll represent to the court, we have a witness from the clerk's office who says that after the grand jury returned the exhibits, they went through without gloves and they were tabulating and making sure all the pages were there, and they didn't know there was a problem. But, aside from that, the most important thing here is that if you then go back to page 421, and I'm guessing that would be in volume 2. Okay. I'm sorry. I'll get the volume number next time I quote the transcript. But if you go to 421, starting at line 23, I'm sorry, line 25, you have the questioner, one of the district attorneys saying, now, I want you to, we're going to break the seal on this exhibit. And they're talking at this point about the black briefcase. I'm going to ask you to look very briefly, young man, at the stuff that's in there. Alright, take a look at the stuff. Now, there's some magazines, correct? Yes. Then there's some sheets that are individual and not in magazines as if they've been torn out, correct? Yes. Now, can you tell me whether or not that was the kind of materials that was in the suitcase that was shown to you? Yes, that was the kind of materials. Q. Does that look like some of the stuff that was shown to you? Yes. And it goes on beyond that. The point is, if, realistically, if this was a point in the proceedings where somebody was wearing gloves and saying, "Don't touch it, I'm going to show it to you," that would be on the record. What's on the record is, we're breaking the seal. We're opening it. Now, young man, look at this. And as you saw from the exhibit, the photograph, the way it was seized and the way it was sealed, all these things are stacked up. So the only way to see if there's other magazines and to see if there's separate pages is for somebody to look through them, for a person to look through them. There's no evidence that the district attorney is looking through them. There's no evidence anybody put on gloves. And so the clear record on this appears to be that the district attorney at that time, remembering this occurred on 3 to 30, and the Sutcliffe occurred on 4 to 8. In other words, it wasn't until 4 to 8, it appears, that somebody said, "You mean you didn't even look for fingerprints? We knew you didn't get any usable prints, but you didn't look for them." And then they go in and make a big deal about gloves in the deliberations. So on 3 to 30, when they're showing it to Gavin Arvizo, it looks, to me, from the record, pretty clearly that nobody was wearing gloves, and there was no effort to do anything to avoid contaminating this evidence by the fingerprints of Gavin Arvizo. Okay, so, having said that, that's our position. Now, does that give the district attorney the right to call a grand juror? And we take the position, no, because the code says you can only call them with regard to testimony. And as we pointed out, that's pretty much obsolete these days because the recent case law, I cited Comiskey, but I believe there's other ones, like Mocharab also talked about it. The courts have said we're entitled to a full transcript of the testimony, so it should pretty much negate the need to call in a grand juror. There may be other ways to do it. A district attorney could take the stand and say what he wants to say. But we have the further problem that we were given the name of the foreperson of the grand jury for the first time 2 days ago. No address, no phone number. The prosecutor had a proceeding in which they had full access to these people. They know all their names. We've never been allowed to know their names. There was an objection when we asked to get their names. The court ordered that numbers be used instead of names. That was done in the transcripts. They come up and say, "Well, here, we have a name." No statement. Except we're going to tell you this witness is going to come and say we did everything right. Furthermore, there were 18 other grand jurors there. We've never been given their names. We have no ability to interview them. So we have that major problem with calling grand jurors. And do we really think it's appropriate to disclose all the names of all the grand jurors and have them all interviewed with regard to whether there were gloves or not, or whatever, about something in the middle of the process? And that leads me backwards to the first point I made, or the first or second in writing, and I'll conclude with this, is that this whole thing, even if the court were to say, "Well, okay, we'll even the playing field. We'll give you all the names and addresses and phone numbers. You can have your investigators go talk to all of them, and then you all can call in competing grand jurors," okay. Even if we did that, and even if that survived a 352 analysis on consumption of time and undue confusion to the jury, the prejudicial effect of bringing in people from a body that made a determination, a quasi-judicial determination under California law and an administrative determination under U.S. Supreme Court precedent, in other words, part of the prosecution, if they're allowed to do that, that is going to be extremely prejudicial, because you've got jurors who are trying to hear the case. They're now listening to a juror who has a vested interest in upholding the process that they went through, the best they could as laypeople, to return an indictment. That kind of evidence to this jury is going to be very prejudicial.
You know, the interesting thing in your argument, though, is that, through excellent cross-examining skills, you, the defense, have put into issue whether or not the children touched the magazines during the grand jury proceeding. So at this point, the state of the evidence is most favorable to you that the inference is strong that they must have touched those magazines. Now, having skillfully done that, and this is not meant to be anything but a compliment.
I'm always worried when I get complimented by the court.
Yeah, I can see you starting to worry. No, I really mean that. Credit where credit's due. But then you say, having skillfully raised this inference, the district attorney should be barred from rebutting that, and that's it. And that's what I find interesting about your argument, is that. Now, let me ask you a question.
Yes.
You don't have to defend your excellent skills at getting to this position.
I do have an answer to that, but.
You have an answer to that. And I would say, if you had been doing the grand jury, I think that would have been covered. but the transcript would have been 4,600 pages instead of 1,800, which I found overwhelming.
The trial would be shorter. Laughter.
I doubt that. What was I saying? How can I lose it like that?
Could I respond a little bit? And I'm sure that will cause the court to remember.
Yes.
I appreciate what the court said, but I think that.
Oh, I know what I was going to say.
I knew if I started talking, that would help.
You did it. You helped me. There's a couple of possibilities that I see here. One is that you're only asking, as well as you did. It's just an inference that they touched. There is no evidence that they touched. We don't know if they touched or didn't touch at this point. But the inference is strong by your examination, the defense examination, that they did. There's a couple of ways we could handle that. One is you could stipulate that they didn't touch it. That would get rid of any prejudice of calling a grand juror, 4% of the grand jury too, and any resulting prejudice. I can see from the look on your face, that's not going to happen.
Right.
But, is that right?
That's correct.
You're not willing to stipulate to that.
We actually believe he touched it. I honestly believe that, for what it's worth.
That being the case, the question then becomes, what is a fair way, if there are witnesses that saw this? And one of the things that we could do would be to call that witness, but not identify them as a grand juror or 4% of the grand jury, but simply say they were in the grand jury room and they observed whatever they observed, so that you don't have the prejudice that you're so much afraid of, this formidable person being called. What do you think of that?
Well, I think there's yet another possibility. So in answer to the court's question what I think about that, I think this. Another possibility is there are other people in the grand jury room. The prosecution. I believe there was a police officer there, or a sheriff there most of the time. Did I just hear somebody say no, there wasn't? I don't want to waste time talking about it if there wasn't a police officer in the room at that time. But that would be a possibility. Certainly the district attorney, whichever one or two or three were there at the time, could testify. I would assume if they're taking the position that something else happened, we're going to hear that. The third possibility is to allow us to have the names and addresses of all the grand jurors. It seems clear, and the reason I say this, there's the obvious reason, but there's a more subtle reason as well. It seems clear from the transcript of the grand jury that there were several grand jurors who asked a lot of questions. There was one grand juror, for instance, who was particularly interested in this fingerprint issue. I don't know who it is, because we only have a number. The prosecution knows who it is, so we're not on even ground here. But one way to do this would be to allow us to have the names of the grand jurors so that we can adequately investigate this and see what they all have to say. In other words, in response to the court's question, I certainly wouldn't want to stipulate the 4% can just come up here and not be identified and say, I was in the room when I saw this, because that's just the problem. The 4% has, and I don't mean to fault him or her.
I think you made a very good point. That other people may have seen something the 4% didn't, or, it's a good point.
But my first position on this, again, is that the government should be, in a way, bound by the transcript, because they're the ones that are making it. That's what the Supreme Court has been saying over the last few years. 25, 30 years, it's been increasingly adamant about the fact that there's a record before the grand jury. The prosecution is the only side in there. They're the only lawyers in there. They have the obligation to make sure that that transcript is complete so it can be reviewed. And if we're going to have a grand jury process where things can be done in secret, where the defense can't be there, the accused isn't there, there's not a judge, if we're going to do this, the only protection is to make sure that the prosecution makes a complete record. So that, the original position that we're taking, I'm going full circle on all this.
No, I understand.
Is that when you look at it, the transcript is the transcript. And the inference from the transcript, as I just read it to the court, is an inference, and the jury should be allowed to hear this testimony or have this read to them. They can consider that along with what other evidence has been put on to determine whether or not the chain of custody on this material was such that when fingerprint analysis was later done after it was released and they allegedly find a fingerprint of Gavin Arvizo, that the jury can say, yeah, we're sure that fingerprint came from February or March of 2003.
I guess I have. You have an advantage that I don't have, too. And maybe you can help me. I haven't heard the evidence on the fingerprint on the magazine or more than one magazine. I don't know. You know. I know from points and authorities something, but I don't know the picture. I don't know if there's a palm print or a...
There's a fingerprint.
Just one fingerprint.
Well, here's the problem right now. And before we discuss this and go into too much detail, I'm always conscious that whatever we're going to say is just going to be in the press.
You can be circumspect. You don't even have to answer that. I was just going to say that I don't know that information.
Let me tell the court this in general terms, is that we don't know that information either, because there have been reports that were given to us showing that there was a fingerprint. Well, showing that there was, in this context, a fingerprint, one fingerprint that we're concerned about.
Okay.
There were others that were determined not to have sufficient data to make a positive identification. There are others where they're absolutely negative. They were excluded. Okay.
All right.
What has happened very recently, in the last 3 weeks, is we've gotten reports that there have been a meeting of various fingerprint people who have now decided that some of these determinations should be changed. And they go both ways. They go. In the sense that they had a fingerprint they positively identified, they're saying, no, we don't think we can say that. And then they said, we've found some others that we said were not conclusive and now we think are conclusive. So we're in flux on this. But the essence of it is that, if this is true, that Gavin Arvizo had a chance to go through these papers so he could see the sheets and he could see the magazines, and he picked them up to do that. If that's true, this would be a very significant piece of evidence with regard. This inference that we have is very significant with regard to fingerprints that are done later. And understand, and I'm sure that, and I don't mean to just offend the government here, but it is.
Do you mean you intend to offend more than just the government?
No. Whenever anybody says that, that means we're really going to offend the government. But, I really don't want to be rude, but, I mean, the fact is, if you look at any case that you have in the ordinary course of criminal law, when do you have a situation where something is referred for forensic analysis very shortly? I don't have the exact dates here, but very shortly after it is seized it's sent over for forensic analysis. It was seized November 18th, and I think it was sent for forensic analysis in November, and they do their analysis. They do an alternate light source. And we will show from, we started to get into it, and then the officer wasn't clear on what 317 was. But the officer on the stand wrote a report saying, please, and these were the words, please do a fingerprint analysis. And he sent the material back with the report saying, please do a fingerprint analysis. And it sat there until March and April of 2004. In March of 2004, now, whatever that is, 6 months after it was seized, it's opened, it's shown to the grand jury, it's booked into evidence, it's handled by the clerk. And then sometime in the summer of 2004, it is taken out of the grand jury, and then it's sent for fingerprint analysis. Now, that isn't the way it should have gone. And I don't know if anybody's going to argue, this is the way we do things, but I've never seen it. I mean, if there's going to be fingerprints, you take them before you book it into evidence.
Let's let the district attorney respond.
Okay, thank you.
After we seized the magazines from Neverland, and there were many magazines that were seized at that time, there were lengthy discussions about how to handle these magazines, and how to process them. It was exactly the opposite of what Mr. Sanger said, that we were suddenly in the middle of the grand jury hearing and were embarrassed because somebody thought for the first time to do fingerprinting. The reality was quite the opposite of that. The question was, do we proceed with fingerprinting first, or do we proceed with a search for biological evidence? The problem is that the process that you use for either the search for fingerprinting or the search for biological evidence could have the consequence of negating our ability to find the opposite. Whichever you go first with could have the problem of destroying the evidence as to the opposite. We had a lot of deliberations, a lot of discussions over many weeks, with a number of people, from the Department of Justice as to how to proceed on these issues, and very cautiously proceeded with each individual magazine and each individual page by initially using alternative light sources that would suggest the presence of biological material, either semen or perspiration or some form of human contact with it that would leave biological evidence behind. There were some cuttings that were then taken, in an effort to minimize the destruction to the magazines, and as a consequence be able to preserve the possibility of finding fingerprints. The actual fingerprint process didn't begin until after the grand jury hearings, partly because the evidence was before the grand jury, at least that portion of it. The evidence that was introduced were the magazines only in that one suitcase. It was not as to the balance of the magazines that came through. There were 19 prints that we were able to identify as belonging to the victims and to Starr and to Gavin, and to the defendant. At the moment, I can't tell you over how many magazines. I don't have that information right in front of us. Counsel was wrong, of course. There are no police officers who are in the grand jury room unless they're giving testimony. The rules are different from a regular court. We're not entitled to have an investigating officer present. So when counsel asked Detective Zealous, "Isn't it true you handed those magazines to Gavin Arvizo?" The answer is, he wasn't in the room when Gavin Arvizo was on the witness stand. We're not allowed to do that. The only time that we had an officer in the room with the evidence was at the time that the jurors were allowed to view the actual magazines. And that was Detective Zealous. And he was the one who handled the magazines and showed them to the jurors. They didn't touch them. And he, of course, wore gloves, as was consistent with his testimony. During the presentation of evidence of the two boys, yes, we did not put on the record that nobody was going to be touching the magazines, although there's plenty of references to the fact that we were maintaining strict control, specifically at the time that the jury viewed the material. You'll see that in the record, that they weren't allowed to touch the magazines at that time. We have asked the foreperson of the jury to come forward and testify to this, because she was the person sitting closest to the witness. And she was the person responsible for taking control of the proceedings and making sure that the secretary had each of the items and that they were marked appropriately, that the witness is admonished, and of course she was in the best position to be able to see what was going on. And she is prepared to come in and testify that the children never touched any of those magazines, that they stayed in the suitcase. And of course if you look to other references to other material being handed witnesses throughout the course of the 12 days that we were in session and the 45+ witnesses who testified, when they were handed an item, we said so. I'm now handing you exhibit number so and so. So it's pretty clear that the descriptives that are being used in the presentation of this suitcase is very different from how we presented other evidence where we really did hand it to them and they were able to take it. But the question is, are we bound by a transcript as to this particular issue? We're not talking about legal matters presented before the grand jury. We're talking about an accusation by the defense that we handed material to a witness, and that witness then put their fingerprints on it, and that we then presented the fingerprints that we found as having come from Neverland as opposed to from a grand jury. Now, that's an accusation that was raised first by the defense, and in his opening statement, Mr. Mesereau, and then by Mr. Sanger specifically in his questioning of Detective Zealous. "You did hand this magazine to Gavin, didn't you?" And he said, "No. In fact, he wasn't even in the room when it was handed. It was not he who presented that information. It was, in fact, Mr. Sneddon who showed the material, and it was in the presence of 19 grand jurors, myself, and Mr. Auchincloss. We believe that it's appropriate for that witness to testify. And we believe it's appropriate for that witness to identify herself as the foreperson, because that is, in fact, the piece of information that makes her the most observant. It is her responsibility, above and beyond the other 18 members of that grand jury, to be attentive to what's going on and attentive to protocol and making sure that these exhibits get to the secretary and get marked properly, and get stored appropriately as well. And I think that extra responsibility on her part, which she took very seriously, which you'll see if and when she testifies, is the indicia of credibility that is necessary to be able to resolve this issue. It's an important issue, and we need.
What about the request that you reveal the names of the other grand jurors so that they can see if any of the other grand jurors saw something different?
Well, they are percipient witnesses to this event. And if the court feels that's appropriate, do it. But our position is it's overkill. That's why she is the foreperson of the grand jury. But again, that's for the court to resolve.
So you think in this courtroom that the judge is a better witness of what's happening at the witness stand than the jurors?
I think that, I would always think that the judge is a better witness than anybody else in the courtroom as to what's happening in the courtroom.
The reason I raise that is that, I'm doing all sorts of things. And I see a lot. I hope I see a lot. But I know at times I don't. I mean, I'm distracted by this or that.
Well, it may be appropriate to do an in-camera examination of other jurors, if the court feels that's appropriate, rather than reveal all of their identities publicly. That certainly is an option as well. Ultimately, I think it's the court's call on this matter. But I don't believe that we should be barred from being able to present evidence to contradict an event that they say took place that didn't take place, for which we do have witnesses. And we are witnesses, for that matter. It's a suggestion for which they have no basis of belief and have no basis of belief now.
Anything else?
No. Thank you.
Your Honor, let's put it this way. It may be a multi-stage process. It seems to me that, for whatever reason, the state of the record is the state of the record because it was handled the way it was handled. We didn't have anything to do with that. We made representations based on our analysis of the grand jury transcript, which we made, I believe, early on as part of the 995, and there's certainly no secret it was made as a part of Mr. Mesereau's opening statement. There's no secret that we had a concern about these items being handled in the grand jury. And I think when Mr. Zonen says there's no good faith basis, if you read the transcript, I mean, how much more clear could it be? Now, that's that part. And I think we're entitled to go ahead with whatever inference we have. We strongly disagree with the calling of the foreperson of the grand jury. If the court is thinking about doing that, we would like to have the opportunity to interview the other witnesses. I think that's only fair. Particularly, but not limited to, but particularly the person that asks these questions about fingerprints, because obviously he or she was very concerned. So I think it's a process that if the court, and the court could say, or it's a multi-step process. The court could say, I agree, they're stuck with the record. Let's move on, and that would take care of it. The court could say, well, I may let you call Mr. Sneddon to the stand, and we can cross-examine him about it, and we'll move on. The court could say, well, I'll let you. We'll consider whether or not you can call a grand juror, which we strongly object to for other reasons, but if the court were going to go there, then we'd want to have a chance to interview everybody. And then, after we interview everybody, have a chance to come back to the court before they call a grand juror, because we can see that it's a very prejudicial, very difficult matter. I mean, you have people. I'm sure the court's been aware that when trial jurors, for instance, are interviewed after a verdict, there's a strong inclination on the part of jurors to argue that what they did was fair. And of course they want to be fair. Most people want to believe that they're fair.
I understand that feeling.
Yes, judges as well, I'm sure. But with jurors who are laypeople, quite often when they're interviewed, will say, well, yes, the first thing they'll say, we were very fair. We evaluated the evidence. We followed the judge's instruction. Of course, like anybody else, they have a vested interest in what they did. And I think there's a real danger of putting somebody up here who's a layperson who will have a vested interest. So, what I'm saying is, if you get past stage 1, we eliminate. That's it. The record is the record. The inference is an inference. And we can argue it. Stage 2. A witness such as Mr. Sneddon, if he wants to testify he was there, we'll cross-examine him. Stage 3. If you're considering jurors, let us interview first and determine where we are, because we may say, after that, that it is so prejudicial to put anybody on, that we want to forego the calling of a grand juror at all. But we'd like to at least have an opportunity to talk to the others, if the court's going to get to that level. Does that make sense?
Yeah. I understand your argument, your approach.
Okay, thank you, Your Honor.
I don't think that the law is at the state that the record is the only evidence of what happened at the grand jury proceeding. I mean, I could picture a situation where somebody challenged the reporter's transcript of what was said and the court had to have a hearing as to the accuracy of the transcript. And the court would have to take testimony from people in the grand jury room of what was said. That doesn't happen very often, but in my career it happened at least once. And it turned out that the court ruled that the transcript was not accurate on that point. So you can't say that the transcript is the only way that anyone can ever determine what happens in a courtroom or a grand jury room. The next thing that the court considers is it's certainly not fair to allow the district attorney to choose one grand juror, albeit the foreperson, and have that person be the only one that testifies. I don't think that the court should be involved in investigating the case. In some countries, that's what happens. The judge investigates the case, brings the indictment, and, not here. That's not what we do here. I don't investigate. So the only time we have in-camera hearings is when there's issues of privacy or privilege at stake that have to be predetermined before, to determine whether or not they outweigh the other interests. So I'm not interested in myself conducting an in-camera hearing trying to examine witnesses. Not only that, I think that would be your job. The only thing that I can really see as a fair situation here would be to order that the names of the grand jurors be given to the defense, and with a protective order that they cannot reveal the grand jurors' names to anyone other than their investigator, who would be bound by the same protective order, and that they be allowed to question those, or to approach them. I mean, it's up to the jurors whether they talk to them or not. It's not ordering people to talk to them, but they need to have that opportunity. It seems also that I don't think I should make. I have some other orders that I might make, but I think I probably shouldn't make those until we find out where we are after that point.
I understand. Could I, with regard to the protective order, we were given the name of the foreperson by the prosecution 2 days ago. We weren't given an address, but we did locate the foreperson. And my understanding is that the foreperson said, I've talked to the district attorney, and I'm not going to talk to you, in essence. That's not a quote, but that's.
They didn't want to talk to you.
They didn't want to talk to us. And they made it clear that they had talked to the district attorney. So there seems to be some allegiance there, which one can understand for someone being in the room with the district attorney for however long that was.
You think that causes allegiance?
It could cause allegiance or could cause irritation.
But that's the problem that you have with all witnesses. It depends on how things go.
I think more so here, simply because you do have this, there. As we outlined in the grand jury, we had Lieutenant Clapakis apparently marshalling grand jurors around, and he was a witness. And you had the district attorneys in there. And there was a lot of camaraderie, and, that happens. Anyway. And they came to a conclusion, and they're in the international spotlight for having come to that conclusion, I suppose. I would just ask in the protective order that perhaps it could be phrased in a way, and perhaps we could submit a proposed order to the court, a written order, that would indicate that the court is specifically authorizing our representative to talk to them about this particular subject matter, the handling of evidence, something general so we don't prejudice the viewpoint. And that they're not obligated to talk to anybody, but the court would appreciate their cooperation with both sides. And we would like to have an opportunity to. I don't know how many grand jurors have been interviewed by the prosecution so far. We haven't gotten reports, and I think that we'd be entitled to them, quite frankly. But if they haven't interviewed grand jurors, to at least give us the first shot at this point so we have a fair chance to really find out what happened. We just want to know what happened. So I'd request those additions to the protective order. And then depending on what happens, we can come back and address the court as to what should happen with regard to actually calling witnesses.
Do you want to respond to that? And you can also respond to what I was saying, if you want.
Our response is that, our preference is that each of the grand jurors be interviewed in the presence of both sides at the same time to avoid needless inconvenience to them and needless intrusion into their time. That there certainly be a protective order that keeps their identity secret and not public. And that there be a restriction on the extent of the examination of the witnesses, and limited only to the issue of whether or not these boys touched the magazines, and not any other issue that may have come up in the 12 days of grand jury testimony.
Yeah, I definitely would put that restriction on. I don't want the grand jurors examined on any issue other than this issue.
Could we, say, limit it to, say, handling of evidence? I just worry about telegraphing this particular issue. It's probably going to be telegraphed in the press anyway. But we really should have an opportunity to just talk in general about handling of evidence, and obviously this is the focus of it.
Well, I think we could, as long as you understand, and you understand, that while the statement is rather broad, that the mission is limited.
Yes, sir. Believe me, we have enough to do. We're not looking for wild goose chases here. We're trying to focus on this issue, so.
You're still looking at me. Is there something you wish me to add or answer?
No, I'm just trying to think. It's a difficult problem.
It is.
I was reflecting, actually, on a statement I made yesterday. I think that we just had a couple of simple things to look at. I took it back right away, but what was I thinking? Let me. I want to sit down with my research team and see if we can ourselves structure an order that will be appropriate as opposed to asking for one from either of you. So let me do that.
Thank you, Your Honor.
Then the next item. Is it break time yet? The next item.
No, Your Honor, you have 3 minutes.
I'll use it, too. Motions to quash subpoena Duchess Teacum on the financial issues. This is what I'm going to do here, is I'm going to deny the motion to quash. Did you have something you wanted to say?
I suppose, but Your Honor's already indicated you're going to deny it. I don't want to argue it if that's the ruling.
We've been through this and through this, you know. So what I thought I would do is to deny the motion to quash, limit the period of time. The subpoenas are too broad. We need to address some limitations on the subpoenas, and indicate that I'm not making any ruling on the admissibility of the records at trial, and I'm not releasing them for their experts to examine. This is not a part of the discovery process. This is a subpoena Duchess Teacum for trial. But I think they should have the records here to the extent that they might be used in trial. It's like a lot of other records that have been subpoenaed. They are not necessarily admissible records. That would depend on how they come, what the issue is at the time they're asked to be introduced, and what the records are. But anyway, that's my proposed order on that.
May I just make one inquiry, Your Honor?
Yeah.
Some of these records will be voluminous. And I'm happy to try and narrow the scope of the request, but there's no way around getting to the issue of the examiner having to see the exhibit and look at it.
See? That's the whole problem here, is that this is not a subpoena for your expert to prepare himself to testify. That is not what a subpoena Duchess Teacum is, and that's not what I'm allowing.
So I guess I'm asking the court, what are you proposing in terms of how? When the expert can look at the documents and
absent a stipulation from the other side, you would open the documents here in open court.
It will obviously be time-consuming.
Well, it may not be, because you'll have to tell me why you want to open them. And they won't be open so you can spend hours thumbing through them and looking at them. And
may I have permission to file some authority for the opening of the documents prior to their examination on the stand?
Yes.
All right, thank you.
And
the point is that you have subpoenaed the records for trial. That's legitimate to subpoena the financial records, because I've already ruled that under your theory, his general financial statement, Mr. Jackson's, general financial statement, can be raised as a motive, as you requested. I agree with you, that's appropriate. And I've ruled that. I have ruled. If it's not clear, I'll make it clear now, that under 352, I find that the amount of time that would be involved in proving and disproving his true financial worth outweighs the probative value of doing that. And under 352, I'm not going to allow a detail-by-detail examination of Mr. Jackson's finances.
And I do appreciate that, and that's why I submitted Exhibit A with our papers. And that really is the substance of the testimony we're seeking to adduce. 1 page.
Just so you see maybe what both sides see what I'm thinking is. The reason the subpoenas are valid is that his finances are at issue in this general sense. Let's suppose you have somebody testify. I think somebody already has said that his finances were at issue. That was part of the public relations effort that should be taken care of, because people were saying that he had bad finance. His finances were not in good shape. But let's say a little further. You had someone testify that, in fact, their belief, based on something legitimate, but not much, that he didn't have good financial standing at the moment, poor cash flow or whatever they say. Then, now, that's all I allow. See? Then let's say that the defense calls their accountant, and then he says, well, they're absolutely wrong, He's worth 8 times as much as anyone thought before, and here it is. Now you've got the records in court, and you say, oh, let me look at the records. Now we have a situation where perhaps looking at the records would be appropriate to cross-examine this accountant.
All right.
So the other way, it doesn't quite work for me. That you call your expert and say, you think he's in bad financial shape. And he says, yes, and he says, let me show you all his records, and see if that substantiates what you're saying. We sit here for 4 days while he goes through them. No, that's not going to happen.
I understand, Your Honor. Thank you.
All right, let's take our break.